Hi, I'm Steve Carlson. I'm going to be a candidate against Tina Smith in the Democratic primary in 2020. And right now, I am a petitioner, a litigant with my wife in a breast cancer treatment case, which is currently before the U.S. Supreme Court. A piece of that. The piece of that that's up at the U.S. Supreme Court is that although ordered to pay for medical care during active cancer treatment under a state program called Medical Assistance for Breast and Cervical Cancer, which is part of a federal Medicaid program called the Breast and Cervical Cancer Prevention and Treatment Act. Although ordered to pay, Ramsey County, where this has been lodged, this program, and the responsibility for completing her treatment, which will run until 2020, they refuse to pay any medical bills. And it's a deadly thing. I know of a person who I've met who has passed away because she was in this program and they cut her off. And most of the women, there's hundreds of women that this is done to in Minnesota alone. Most of the women that this is done to don't have any idea what's happening and why they're not going to get any further breast cancer treatment coverage. And it comes back. It's a deadly thing. They don't get the medical care that they need and they die. And this is completely contrary to what the U.S. Congress said when they passed this law in 2000. This was passed by both the House and Senate, signed into law, I believe, by George W. And it says they're going to get appropriate treatment because for 10 years they've been watching women die because they wouldn't pay for their treatment. And now Minnesota has decided, as you will hear from this document I'm going to read from, that they would rather take that money and spend it on other things. And specifically, they note to give it to the most impoverished patients or recipients of welfare because it can be spent on anything. It doesn't have to be spent on medical care. And take it away from these women while they're in cancer treatment. And this is a deadly mistake. Now, the whole case is not up before the Supreme Court yet, only the piece that they refuse to pay on appeal. And so this is an emergency application. The cert petition is available online. The case is 18-8511 of the U.S. Supreme Court. So you can go up, look up on the docket, in Ray Victoria Carlson et Veer, that's me, the husband, number 18-8511. I'm reading from the emergency application, which says, please just immediately order them to begin paying for this medical care because it's a deadly thing. And we thank God. We're Christians, and we thank God that He has preserved Victoria against this. Okay. So this is to the Honorable Neil Gorsuch, Associate Justice of the Supreme Court of the United States, and Circuit Justice. Each circuit has a justice assigned to it for the Eighth Circuit. Nearly 50 years after this court struck down a New York City and New York State procedure in Goldberg versus Kelly that had allowed and would allow New York recipients of welfare benefits to be terminated without a hearing, a state district court in Minnesota, which has approved a cancer care coverage termination without a fair hearing, has denied petitioner Victoria payment for medical care benefits during her cancer treatment and during her appeal of that deprivation from her favorable commissioner's ruling, notwithstanding. So her favorable commissioner's ruling notwithstanding. I guess that was written correctly. Victoria is a BCCPTA, Breast Cervical Cancer Prevention and Treatment Act, breast cancer patient in active treatment. But she has been deprived by the county respondents of any Medicaid dollars since late 2016, and this is in 2019 that I'm recording this, to the present. And all of the respondents intend to maintain this deprivation during the period of her remaining treatment. The applicable statutory limitation period states the medical care benefits will be paid, shall be paid, to as long as the ongoing breast cancer treatment is required. See Minnesota Statutes 256B.057, subdivision 10B. See also BCCPTA of 2000, Section 2, optional Medicaid coverage of certain breast or cervical cancer patients. A, coverage as an optional needy, categorically needy group. Limitation on benefits as subsection 3. And they bar it during her appeal from that deprivation of Medicaid dollars. And the state appellate courts have upheld that practice. Talking about the Minnesota Court of Appeals, the Minnesota Supreme Court. That's Lori Gildea, the Supreme Court Justice. The decision, which is part of the appendix, which you can see online at the case, to bar Victoria from MABC benefits pending appeal of the deprivation, has been made by the State Appeals Court, apparently on grounds that respondents characterized the order of the commissioner reversing their actions. Respondents are talking here about Ramsey County respondents of the Ramsey County Community Human Services is where they house this, because they treat you as a welfare recipient just because you're admitted into this program and your breast cancer is being treated. All of a sudden you're on welfare. Okay. And they've characterized that order, which reversed the Ramsey County actions, as a, quote, favorable outcome for the agency, even though they were reversed in order to take corrective action. Review of that payment bar is sought here in the pending cert petition number 18-8511, and this is an emergency application. The cert petition is available online at the Supreme Court. You just check the docket for 188511. Now, we maintain that Goldberg versus Kelly, already mentioned, Board of Regents versus Roth from the United States Supreme Court from 1972, and the 14th Amendment U.S. Constitution Due Process Clause require a prior fair hearing to deprive Victoria. And you can also see Minnesota Statutes 256.045, subdivision 3, about fair hearings required, 42 USC 1396A3, subsection 3, and that's a requirement of the federal law. So this is going to the U.S. Supreme Court regarding violations of federal law. And she's been deprived, although she's an eligible recipient, of her rights in the cancer treatment coverage. And we maintain that characterizing the denial of a fair hearing is not such an adverse outcome as to block payment of benefits pending appeal. In other words, just because they say it's adverse when they got reversed and corrected and told to pay, restore payments, and they all admit that is not such a thing as would allow them to block benefits pending appeal. And in fact, they were ordered to pay benefits pending appeal. So we further contend that a state law implementing the Medicaid Act, and that's Minnesota Statutes 256.045 subdivision 10, requires continuing payments all the way, and I quote, to the Supreme Court, unquote. And that along with the 14th Amendment, was the basis for the petition for mandamus, which is also in the appendix, which was finally determined by the Minnesota Court of Appeals, and for which certiorari has been timely petitioned. So this is before the Supreme Court. Now it's up for conference. It's distributed today, I guess. And today, I guess, is the 8th of May. And so perhaps it was yesterday, but 2 weeks after it was distributed, is to come before the United States Supreme Court in conference on May 23rd. Both Keith Ellison, the fighter for the people, right? Big attorney general that hates junk, health insurance, and the county attorney, John Choi, have declined to file any answer to this, at least to the cert petition. I don't see an indication that they filed any answer to this emergency application, but I'll continue to check for that. But they've waived their right to file with the Supreme Court, and so they'll do something on or after May 23rd at the U.S. Supreme Court on this. Now, moreover, we see the provision of benefits pending appeal from a proposed deprivation as one of the essential liberties which, when denied, infringes upon and unduly burdens the right to the type of breast cancer treatment coverage promised in the Medicaid Act, as amended by the BCCPTA, which I've spelled out above, rendering such state statutes and regulations supporting that denial invalid and unconstitutional under the 14th Amendment Due Process Clause. Minnesota laws cited by the state appellate court to bar benefit payments pending appeal should be seen as constitutionally invalid, as infringing on and unduly burdening the right to complete cancer treatment with the federal state coverage. These include a 10-day requirement to formally contest notices notices to terminate the coverage, or else that coverage is automatically lost. In other words, that 10-day requirement, which the state uses and the county uses, but they lie about it, okay, that if you got that notice, they would just cut your benefits off. And until you win the appeal, you'll never get those benefits back. And they do this to hundreds of women in Minnesota alone. And it isn't just because they're nearing age 65, as happened here. The person wasn't 65, but they figured they would be. But for any reason, but especially if you get this notice that you're going to be terminated from your breast cancer treatment coverage, and then you don't respond in 10 days. By the way, it has to be with a specific affirmative request to keep your payments in place on appeal. Otherwise, they're gone. Now, this is killing people, all right? And this is not going to be allowed, okay? This is what has kept me very busy since 2016, when it happened, while I was, by the way, a candidate for the U.S. House and also writing candidate for U.S. President. All right, and also especially when Amy Klobuchar, who supposedly was by acclamation, she was named the Democratic Party's nominee for U.S. Senate. But the day before those caucuses start, I had to stand in front of this Mark Dayton, buddy, associate, friend, and appointee. This is her name is Bartsch, Sean Bartsch. I don't think she should be reelected when she's up for election in 2020. And be basically yelled at and threatened while I attempted to defend the right to complete cancer treatment. And that kept me very busy. So it's very difficult to run against you, Amy. And Amy knows this. And she takes advantage of all of these little legal or illegal things that could help her opponents. So anyway, I've been very busy. But to get back to the facts of this case, every time the agency, and that's Ramsey County Community Health Services, every time they sent us petitioners an adverse notice beginning October 5th, 2016, that's that they were going to terminate the coverage, and running to June 15th of 2017. And this is the day the agency, having lost at the commissioner's administrative appeal, sent a notice that they were going to cut it off anyway. They weren't going to restore it. They were going to defy this order from the Commissioner of the Department of Human Services. And it would end on July 1st. So we filed, every time we got this, diligently filed a timely appeal, and we pursued our appeal. So now, based on our appeal, which started just days after this notice on October 5th, they were going to cut off this breast cancer coverage. And in fact, but they already had done it. That's what the commissioner found. They'd already cut off, and they were going to terminate her from getting MA or medical assistance with a spend down after we supposedly could pay, while she's in cancer treatment, $500 a month on medical assistance, and then they might pay some medical bill for her treatment. Now, we did get Medicare covering part of it, but the bills are piling up, and we've been denied treatment unless we came up with the money to pay those bills for treatment that remained after Medicare. And this is done to all the women in this program. And like I say, it's a deadly practice. Now, based on our appeal, an administrative law judge, ALJ, on June 8, 2017, ruled that the agency, Ramsey County, had wrongfully and unlawfully terminated petitioners' medical assistance for breast and cervical cancer in July of 2016. So they had already done it in July. This was a ruling from the commissioner, and they notified us in October. Now, if you know anything about Goldberg versus Kelly and the legal requirements, you're supposed to get notice, adequate and timely notice, in order to defend yourself against getting cut off. But they notified again in October, which is like 4 months after they already cut it off, and didn't even contact us or tell us what they were doing. So this is obviously unconstitutional and illegal. And we expect the U.S. Supreme Court to find that. And we actually expect some support from the Minnesota Court of Appeals, which is still looking at the merits case on this issue, on this matter. And they cut it off in July of 2016 and began to charge the petitioner and her husband, that's me, a spend down, what petitioners refer to as a Schweiker spend down. And that's because it's authorized by the U.S. Supreme Court in this application, this court's 1982 ruling as applied by the state of Minnesota. And in that, and I covered this in a footnote, I don't want to read all the footnotes in this, but in the Schweiker case, basically they impose a punitive spend down requirement which forces Social Security recipients to pay their income down to 80% below cash poor poverty level. And that was, they wanted to discourage Social Security recipients, and Congress wanted to do this, but they didn't say anything about the cancer patients. They just wanted to do this in 1982. Now, they didn't mention this, and it wasn't carried over into the 2000 Act on the Breast and Cervical Cancer Prevention and Treatment Act, but they're applying it here in Minnesota. And they felt that there were rich Social Security recipients who were taking advantage of Medicaid by including their spending down in some states, New York and in Massachusetts at that time, to the poverty level when you counted their medical payments. And then they were accessing Medicaid benefits. And many in Congress felt that the New York recipients and now the Massachusetts recipients were taking advantage of Medicaid, which was intended for the most impoverished. I want to note quickly that anybody who qualifies for the MABC is low income, and they also waive the income requirements for those people. And really, they only need to meet a 250% of poverty level requirement in order to receive these benefits. It has nothing to do with Medicare. I'll also say this. If you receive Medicare and it pays 80% of your cancer treatment and the whole bunch, template of Medicaid treatment required by the Medicaid Act, other provisions, this is specifically spelled out in the Medicaid Act that Minnesota is violating. So you still have 20% that's unpaid. And so the state and the federal program would only be paying 20%, where before they were paying 100%. So it's a big reduction. But instead, they just are knocking people off of Medicaid medical assistance altogether while they're in active cancer treatment. And this is just ridiculous. I heard today, big press conference by Hakeem Jeffries. Oh, the terrible things of pre-existing conditions like cancer. Right away he says cancer. Well, what are they doing to these people with the pre-existing conditions? These are people in treatment. Do you think they can go out with their pre-existing conditions and purchase a nice supplemental Medicare program to make sure that they get the treatment they need? Now, if they don't get the treatment they need, I don't want to play doctor here, but I have submitted a lot of well-documented studies from the federal agencies themselves that this poses a great risk. And I can get into more of that further in this application, emergency application. It's filed under Rule 22 of the Supreme Court rules, by the way. So that's what a Schweiker spend down is. And we contend that this practice of putting this punitive Schweiker spend down on patients is invalid constitutionally as vague and ambiguous, because it just treats everybody differently, and it's clearly not in the law, and as unduly burdening the underlying right to breast cancer treatment coverage. Then, as the ALJ, the Human Services Judge Ellen Longfellow, ruled, Ramsey County on October 5th, 2016, violated applicable state statutes requiring notice preceding a termination of benefits by treating petitioner as ineligible for MABC when they proposed to terminate her from medical assistance with a spend down, the Schweiker medical assistance. We were losing that. We couldn't even get coverage if we paid $500 a month, according to what the county was doing. And she ruled it was for an erroneous reason. Now, Goldberg specifically says the whole purpose of the prior hearing requirement is to avoid erroneously treating an eligible recipient as ineligible. And this erroneous reason that they were terminating her is she had not filed any spend down reports with the county since July 2016. Now, that action and the July 2016 action terminating her from medical assistance breast cervical cancer, July 2016, were reversed by the commissioner June 8th, 2017. Like a year later, they're reversed. All this time with no benefits. And that's in the appendix. Nearly a year after the termination. Now, this is not a favorable ruling for the agency, nor is it an adverse ruling for petitioners. Corrective action was ordered, and we put exactly where, if you want to look at the cert petitions appendix. Now, however, the agency, Ramsey County, refused to comply, as noted, and denied petitioners the required corrective action of benefits payments on appeal, and in fact denied any appeal or any fair hearing that could fulfill the requirements of the 14th Amendment, which might have allowed them to deprive Victoria of her medical assistance breast cervical cancer benefit payments at all. They just referred to the June 8, 2017 Commissioner's order, which did not support their actions. They reversed their actions, and they did not follow it, but misused it. Medicaid dollars are needed during remaining breast cancer treatment scheduled through November 2020. 1, to pay the balance of the medical care not covered by Medicare. And 2, maintain the requirements of Medicaid law, which I've referred to some of them, for the equal amount, duration, and scope of those who are on the program only because they are in the Medicaid BCCPTA. So they're only getting Medicaid dollars because they're cancer patients in the treatment program. Now, these provisions, along with the others mentioned and argued in the courts below, assure us that Congress or the Medicaid Act did not intend to deprive Victoria of these vital benefits through the BCCPTA. But that entire issue is still pending before the Minnesota Appellate Court, Court of Appeals Court. And they're scheduled to have a non-oral conference on May 22nd. So that's like one day before the U.S. Supreme Court is to meet in conference and consider the cert petition, which you can find. It's number 188511 on the docket. Now, but on October 16th, 2018, so this is years later, a panel of the Minnesota Court of Appeals upheld the actions of the Ramsey County Agency and a Ramsey County District Judge that the commissioner herself acknowledged is wrong, and the commissioner ordered Victoria to be paid that MABC payment pending appeal. And the district court followed a procedure that is identical to the law this court declared unconstitutional in New York in Goldberg by terminating Victoria without a prior fair hearing. The Minnesota appeals decision is in direct conflict with this court's ruling in Goldberg. Minnesota's bar to payments pending appeal, where the commissioner holds no woman attaining age 65 during her breast cancer treatment may obtain further medical assistance coverage to completion of her promised treatment unless she and her household spend on with medical bills they pay to 80% of cash poor poverty level. And this drastically reduces and terminates breast cancer treatment access throughout the state for low-income women just at the time and the age they need it most, while drastically raising the risk of relapse into cancer and mortality, while providing no benefit to women's health or safety. In this case, it is reducing mobility, risking weight gain, which is a factor shown in a recent New England Journal of Medicine study to significantly raise the risk of breast cancer. Now, I'm going to read just a bit from this footnote. I've skipped 12. This is an important footnote. The International Agency for Research on Cancer, IARC, quote, on the basis of these data, we termed the attribute excess body fatness and reaffirmed that the absence of excess body fatness lowers the risk of cancer at the organ sites that have been identified previously, and this includes breast cancer, unquote. And yet the Washington Post reported April 14th, just weeks ago, 2019, in the disturbing links between too much weight and several types of cancer, that's the name of the headline, by Lori McGinley, that while smoking has become the number one preventable cause of cancer for decades, it still kills more than 500,000 people a year in the United States. Obesity is poised to take the top spot as Americans' waistlines continue to expand while tobacco use plummets. The switch could occur in 5 to 10 years, said Otis Brawley, and he's a Johns Hopkins oncologist and former chief medical officer at the American Cancer Society. And he was in that position when I worked with the American Cancer Society. And that's why I've been shocked by this conduct by the state. The rise in obesity rates could threaten a steady decline in cancer death rates since the early 1990s. And a lot of that has been caused by this attack on breast cancer, including the Breast and Cervical Cancer Prevention and Treatment Act, because this is saving a lot of lives. But it's also risking and losing lives as well. Now, this is a severe danger, I say, to these women denied the full medical assistance they have been promised. If the agency knew about this, or the commissioner knew about it, this headline, this study, they might act differently. This is irreparable injury. And this court, in ordering the resumption of payments on appeal, and we we can get another note from the oncologist if the commissioner wants it, showing the continued need for treatment. This court, the U.S. Supreme Court, should void the Minnesota statutes, regulations, and practices which create this irreparable injury which unduly burdens the underlying right to the cancer treatment and the coverage and the liberty to complete the treatment as a statutory entitlement and fundamental right. So that's a footnote talking about that New England Journal of Medicine study and the very recent Washington Post article, for which I, for once, am very thankful to the Washington Post. Yet, in defiance of Judge Longfellow and Goldberg and other 14th Amendment precedents, the agency, Ramsey County, refused to allow a hearing or to pay BCC PTA MABC benefits on appeal. Technically, the MABC benefits were restored from the time petitioners received the June 15, 2017 notice of the agency that the benefits would end like July 1st, about 1 week after having been terminated since July 2016, when Victoria's BCC PTA benefits were terminated without notice and without contacting her by the agency respondents. The commissioner, following the agency's refusal to pay benefits pending appeal or allow an appeal, failed to enforce the law and unlawfully failed to enforce the order to the agency for corrective action. Petitioners believe that because ordering corrective action of restoring payments was a favorable decision for us, because of the constitutional requirements expressed in Goldberg in a number of cases of this court, because there has not been a fair hearing to deprive Victoria of her benefits, payment of those benefits must be maintained pending the appeal. Then Commissioner of the Minnesota Department of Human Services, the named respondent, named by the Supreme Court, we named Tony Lowry, but they named Emily Johnson Piper, adopted the recommendations of Human Services Judge Ellen Longfellow on June 8th, including her order to restore MABC benefits pending appeal. But the Minnesota judiciary has relied on deference to an out-of-control Minnesota Attorney General, that's Lori Swanson and Keith Ellison, an unpredictable commissioner of the Minnesota Department of Human Services, in order to reach their desired result of stuffing the challenge to their danger. That means we're not going to allow a challenge to this dangerous, although lucrative practice, because they have access to the funds of the MABC patients who have been defunded. Before the record can even be made clear, so before we even knew what they were talking about, they refused to pay. And the federal law and constitution was not yet applied to protect the lives and property rights. See the discussion of Roth and also pediatric specialties, an Eighth Circuit decision, in the pending cert petition of vulnerable women facing a deadly disease. The commissioners and Minnesota appellate court's extraordinary actions and decisions warrant interim relief from this court. The Minnesota appeals decision also reopens a conflict the courts have never resolved. The commissioner told Judge Barch in open court that, to their knowledge, this is the only legal challenge ever to the implementation of the BCC PTA law itself in Minnesota, which excludes women in the program itself during their statutory limitations period. In other words, the statutory limitations expressed in the statute makes them eligible, but they're excluded. It's never been challenged in court. Now, disallowing a fair appeal challenging it imposes an undue burden on the right to payment for medical services incurred during the statutory limitations period. That means when they require continuing breast cancer treatment that they've been promised and it's already started. They cut it off. Now, enforcement of Minnesota's massive program change from MABC to an elderly program They put people on an elderly program with a punitive spend down, meaning they'll never get any money, will have disastrous consequences for women in the state. Without an order granting continuation of her MABC benefits pending appeal and a fair hearing, any relief ultimately awarded by this court could come too late. She may not survive the disease, or her health may fail. Early in the proceedings, the commissioner granted appellant's request for corrective action and a fair hearing, barring the agency from enforcing its action of transfer and program change to the elderly program without adequate notice and a fair hearing, with the critical element of payments pending that appeal from that fair hearing. But Minnesota made a false account of the applicable laws, and in particular, the subdivision 10 that I've just referred to of the statute 256.0451, and they unlawfully failed to enforce the commissioner's own order. And the Minnesota Appellate Court granted Minnesota's request to deny enforcement of that order. Interim relief is warranted now for the same reasons that the commissioner granted it before. Allowing Minnesota's unchallenged automatic transfers and program change from breast cancer to elderly program coverage and zero benefits for cancer patients will cripple the breast cancer treatment access for low-income women in the state of Minnesota. And by contrast, Minnesota will suffer no harm from continued payments on appeal to Victoria. Even the commissioner herself acknowledged that civil rights and the Constitution were not considered, although raised by petitioners in this crucial matter, the undue burden of cancer treatment or on the cancer treatment to ensure women's health or safety, and further held there was not adequate notice to petitioners when she reached her determination on the propriety, legality, or constitutionality of transferring petitioners from the breast cancer, from being breast cancer eligible recipients. They're receiving it as being eligible, or their families to the elderly program with a spend down to 80% of poverty level, which occurred in 2016. So she said that was done without adequate notice. And in fact, there was no adequate notice when we had the evidentiary hearing in April of 2017. So she said you have to give adequate notice. You can't tell them you're removing them from the elderly program because they were eligible. She was eligible for the breast cancer treatment when you did this. You were wrong. You're reversed. You're corrected. Is not favorable for Ramsey County. Now, no harm could conceivably result from maintaining women's access to MABC treatment coverage in Minnesota while challenging this through appeal. Right now, this is the only appeal. Now, we are asking for a statewide moratorium on this practice, but this application is just to pay her an appeal. Would they want to do that for all the women in Minnesota in the breast cancer treatment who are being treated this way? Certainly the court, sitting as the court, has the right to do this within their discretion. It has been raised in the cert petition. Could a single justice do this before May 23rd or before the case below comes to them after going to the Minnesota Supreme Court? I think maybe they might. I can't offer an argument on that because I really am not that familiar with Rule 22 practices applications to a single justice, which is what this is. So I'm going to end this now. This is really just an introduction within this application. There's other parts of this which I'm also going to read and post. I'm posting this on my YouTube. I'm posting it on my website, which is for my campaign against Tina Smith, who, by the way, is part of this. She worked for the governor while this was being done. She worked directly with E.J. Piper, Emily Johnson Piper, who was Governor Mark Dayton's attorney, general counsel. So she's a lawyer and she knows better. And she was transferred to be the commissioner of the Department of Human Services, did a horrible job, did not continue on with Governor Tim Walz. And so I'd like you to consider this. Please, if you're a lawyer or some kind of organization, I'd love to see people filing amicus curiae briefs in this matter. This has never been challenged in the country before. There's one case in Idaho, which we cite, in which their Department of Human Services, it was called Department of Public Welfare, I believe, was reversed because they took a woman off of the hormone therapy, which now in many cases extends the treatment period to 5 years or more, where the government was arguing at that time that it should probably be less than 1 year. But that involved end of treatment regulations passed by their state's department. Ours is similar. However, in that case, there was no discussion of anybody attaining age 65 because, to cut to the chase, what they're saying is that the initial eligibility requirements, which are spelled out in both the federal and the state statutes, which I've referred to, also operate during the treatment so that if the patient attains the initial eligibility requirement age of 65 years old, while she's in treatment, she's treated as if she was not eligible. Basically, had never been eligible, but she's eligible for a few years or a few weeks, which is not what Congress wanted. And I have cited at length the congressional record of debate on this from both the U.S. House and the U.S. Senate from 2000. It is part of the record of this case. And so I'm just going to leave this with you. Thank you for listening. I urge you to support this case, this appeal, and to tell the Minnesota courts and Minnesota bureaucrats and politicians, including Amy Klobuchar, Tina Smith, Betty McCollum, that no, you may not do this to women. Knock them out of their promised and partially received breast cancer treatment. We're not going to allow this. We don't want to give you control. We don't want to give you control over our health care and impose death panels and rationing to women already in the program. This is devastating. This is not acceptable. I'm sorry, but I didn't want my wife to inadvertently walk into this short recording. Again, thank you, and hope that you'll seriously consider this matter with us.